Kana ko Adrian Rafi.
Roria hareruia, tēnā koe te mana o te komiti o te whare nei. Tēnā te mihi ake ki a koe hariko ana hau ki a tuake ki te kōrero ki wahanga toru o tēnei pire I tēnei wā. Mr. Speaker, Mr. Chair, I'm really concerned about this bill overall, but in particular in part 3, in clause 68, which was pointed out by my colleague Trevor Mallard. And what concerns me is this bill giving that kind of power to the government. In actual fact, in earlier clauses where it says, and I know we're not debating this issue, but it is relevant to this clause, clause 26, where it says number 4, each extension is to be for a period the returning officer thinks necessary up to a maximum of 14 days. Well, in actual fact, this clause here, clause 68, overrules that because it says that by order in council, the Governor-General can change that. He can change that clause. So, and there are a number of other clauses in part 2 that can be altered because of what this clause allows it to do. Mr. Chair, I think it's a sad day for our democracy, and we heard from members opposite talking about this bill as being about democracy. Well, I want to talk about, in relation to that and other clauses, access to democracy, because in Māori electorates, where in my electorate, where the turnout for the last general election was 65%, quite low compared to other electorates, but under a postal ballot that this bill allows, we're going to get even less participation. And I think this validation of irregularities goes to point out that I think the government even thinks that there could be situations where the process is not necessarily followed, or they need a bit of wriggle room to change the time frame in which things can happen. And so we should all be concerned about that, because calls from the members opposite around this issue being an issue of democracy, I'm afraid to say I totally disagree about what this bill intends to do. It has been dressed up to do something else, and clause 68 validates that issue, not the irregularities, although it gives powers for those irregularities to be rubber stamped afterwards, after the fact. So if, as in one of the clauses in part 2, that information can be received in any language that the voter wants to receive that in, if that doesn't come in a timely manner whereby that person is able to fully participate in this process, then there's an out clause in clause 68. Because they can overrule that. And I think that is counter-democratic, and members opposite should have a think carefully again about this particular clause and what this does. I think it should be that the process, the methodology for this referendum, and I've got to say, sir, that postal referendum is a 20th century methodology, and we actually need democratic processes to be in the 21st century. And that means, for me, electronic voting. Facsimiles are not. I think it raises the whole issue, and we heard members opposite also talk about responding to local body elections and the low turnout there. Well, that actually raises a bigger picture. So what are the
Paul Stewart next.